Call on the Canadian Constitution Foundation, please.
All right, so my name is Janani Shanmuganathan, and I am counsel for the Canadian Constitution Foundation. And the issue I would like to talk to you about today is the definition of threats to the security of Canada in the Emergencies Act, okay? So we know that Section 16 of the Emergencies Act refers to the definition in the CSIS Act and says, threats to the security of Canada has the meaning assigned by Section 2 of the Canadian Security Intelligence Service Act. Now, we heard from Mr. Vigneault earlier this week, and he's the director of CSIS, and he told us that CSIS has a very clear understanding of what threats to security of Canada means in the CSIS Act based on legal interpretation, jurisprudence, and federal court rulings. And we also heard from him that as far as CSIS was concerned, in terms of what was going on during the convoy, the definition of threats to the security of Canada in the CSIS Act had not been met. Now, are you aware of his evidence on this point?
I am, but then the CSIS director did go on to say that he supported the invocation of the Emergencies Act in this context.
So you'll agree that as far as CSIS was concerned, the definition under the CSIS Act had not been met.
I disagree with that. I have already, with counsel in a descriptive way. Again, I should start with the initial caveat that I'm not going to. I'm going to be careful with respect to solicitor-client privilege. I'm not going to link facts to arguments in a way that can impute the kind of legal advice I may or may not have given or may not have been given to me in this process. And I have to maintain that privileged argument. But I think you have heard from a series of witnesses this week, including Mr. Vigneault, including the exchange I had earlier with counsel, that the incorporation by reference of Section 2 of the CSIS Act into Section 16, given the different purposes of the CSIS Act, given the different goals that CSIS has with respect to why it is using a Section 2 definition for one of its investigations in order to get to further inquiries, is different from the context in which it has been incorporated into the Emergencies Act, and the decision-making body is different. It is not CSIS. It is the governor and council. So there is a wider, as you've heard from a number of different witnesses this week, there is a wider set of inputs that are more than just CSIS inputs. You've also heard from CSIS about the specific rules of thumb that they use in order to interpret Section 2, which aren't necessarily imported into Section 16 because it's a different decision maker.
And all I want to confirm, sir, is that as far as CSIS was concerned, using their interpretation of threats to the security of Canada, that definition was not met under the CSIS Act.
And for the purposes of CSIS in the CSIS Act, yes, I'll agree with that.
All right. And now, we've also heard that Mr. Vigneault was provided a legal opinion that explained the separate interpretation of this definition under the Emergencies Act, and I take it if I asked you anything about the substance of that opinion, you'd say it's covered by solicitor-client privilege?
Indeed, I would.
All right, and now I just want to understand, who is the client in this solicitor-client privilege? And the reason why I ask is, who is the person that we need to approach to waive this privilege so that Canadians can understand how the government arrived at this different interpretation of threats to the security of Canada? Who is this client?
Well, the client is the government of Canada. I don't think I'm telling tales out of school when I say that in closing argument, I believe these kinds of questions will be addressed by counsel.
All right, and so I want to now shift and take you back in time to look at what Minister Beattie, the Minister of National Defence, who was the sponsor of Bill C-77, the Emergencies Act, said about the definition in the Emergencies Act when the legislation was introduced. So if I can ask to bring up POE.CCF 60 3. And just for context, this is a speech that Minister Beattie gave to the House of Commons debates during when Bill C-77 was debated. And specifically, I'd like to go to page 5, please. Is that page 5? Perfect. So I just want to take you to the highlighted portion. Perhaps if we can make it bigger so that Minister Lametti can see it.
I'd prefer it smaller so that I can see the context, please.
So just want to take you to
fine the way it is.
So the highlighted portion where it says likewise, what Minister Beattie says is likewise, it has been said that probably the most contentious clause in this bill is the one that deals with public order emergencies. This is the type of situation which gave rise to the use of the War Measures Act in 1970. This clause takes its definition of threat from the Canadian Security and Intelligence Services Act. This fact alone should make us very cautious because of the difficulties already encountered with CSIS in determining what is subversion and what is legitimate dissent. That was one view of the legislation. He goes on to say, I would remind members of this House that the definition of threats to the security of Canada received exhaustive scrutiny by Parliament in 1983 during deliberations on the CSIS Act. The language in this definition has therefore already received Parliament's blessing. So I pause here to note that what Minister Beattie is saying is, we are specifically incorporating the definition that's found in the CSIS Act because this is a definition that Parliament has already blessed. Is that fair?
Commissioner, again, going to Hansard's is something that is frequently done in the course of legal argument to interpret a statute. It's my submission this is not a matter of fact evidence. This is a matter of argument which will be done at the end of the case, and it's not a proper line of questioning for this witness.
So I would say in response that, this is something that I'm asking Minister Lametti to explain about how, he's offered an explanation for why there's a different interpretation under the Emergencies Act because the purpose for that definition is different, or determining the purpose is different. And what I say is, well, I'd like to look to see what was described as the purpose under the Emergencies Act and why they use that particular definition. So I would say that it is an appropriate line of questioning.
I think it's appropriate to ask him what the purpose of the CSIS Act is, if that's what you're doing, as I understand it. And I'm not sure that requires anything beyond his understanding. I mean, if it's a legal interpretation of what the CSIS Act means, that's different. So what is it you're trying to get at from him?
So what I'd like to do is I would like to go through Hansard and have him confirm what the understanding was in terms of what Hansard said about why they used the CSIS Act definition and incorporated it into the Emergencies Act.
Yeah, I'm not sure he can interpret any more than read the words, but I think that's the best you can get from him.
Well, the point that I was going to make, Commissioner Rouleau, was in the very next paragraph, which was the CSIS definition is embedded in the Emergencies Act and it must be read in conjunction. And that changes the scope and the decision maker has changed, and that's all really I'm comfortable saying.
And sorry, Justice Rouleau or Commissioner Rouleau, Minister Lametti is referred to a following passage in the highlighted portion. And if I could, I just want to go to the next passage so I can ask him a couple of questions about it because he's now commented on that.
Sure, go ahead. Let's see where it goes.
Thank you. So Minister Lametti, you referred to the fact that must be read in conjunction with the definition of national emergency. So when you move to the next page, to page 6, What the entire paragraph says is, I would also remind the House that the definition at the head of each of the four major parts of this bill, including the definition of threats to the security of Canada, do not stand alone. They must be read in conjunction with the definition of a national emergency in the preamble of the bill and in conjunction with other restricting provisions. In other words, before the government can declare a public order emergency under Part 2, the emergency situation must correspond to the definition of a national emergency as stated in the preamble. They go on to say, I am told that this double test, as it is called, will be used by the courts to assess the government's compliance with the deliberate constraints and safeguards that have been built into the definitions of this bill. So what I'm saying, Minister Beattie is saying here is that you have to, one, meet the threats to the security of Canada. That's the first part, but also meet the definition of a national emergency under the preamble. That's what he's referring to as this double test.
That's certainly your point of view.
All right. And is it fair to say that they're not saying here that the interpretation of threats to the security of Canada changes because you're looking at it through the lens of a national emergency? They're talking about this two-part test, a double test.
Again, Mr. Commissioner, my friend's question is calling upon the witness to interpret what we see in the Hansard. The Hansard is what it is, and beyond that, we're getting into legal argument on the interpretation of the legislation.
So I'm afraid you're also out of time, so you're going to have to wrap up, and I think you've probably gone about as far as you can with interpreting Hansard.
Okay. Those are all my questions on that. Thank you very much.